In episode 26, titled Navigate Legal, Regulatory, and Privacy Responsibilities, we frame compliance as a no-surprises set of guardrails that actually enable the business to move faster. The promise is simple. When rules are clear, mapped to systems, and verified with evidence, teams ship with fewer late reworks and leaders face fewer ugly surprises. Compliance stops being a brake and becomes lane markings, rumble strips, and reliable signage that let people drive at speed without drifting into danger. Our goal is to make that picture real with concrete practices that tie laws and standards to assets, processes, and decisions in language the organization already uses.
The first practical move is to identify applicable laws, regulations, and standards by industry and geography, then map them to systems and data flows. Begin with the obvious anchors: financial, health, children's data, critical infrastructure, and the markets where customers reside or services operate. From there, match each rule set to business processes and the systems that support them, documenting which applications, interfaces, and storage locations come under which obligations. Create a living matrix that links each requirement to a system owner and a verification method, so questions route to the right person, not to a mailing list. When a new market opens or a product feature lands, this matrix expands predictably instead of spawning crisis meetings and platitudes.
Plain language around data categories is the next hinge. Define personal and sensitive data in concrete, testable terms, and locate those fields across applications, logs, analytics stores, and backups. Personally identifiable information, PII, should not float as a theory. It should be a cataloged set of elements, names, emails, identifiers, biometrics, tied to schemas and columns. Sensitive classes such as health indicators, precise location, or financial credentials deserve explicit tags and handling rules that follow the data into derived tables and search indexes. Include logs and backups because many breaches and discovery requests touch those layers where teams assume no one is looking. When data categories are visible in inventories and lineage diagrams, policy stops being aspirational and becomes operational. Lawful processing must be deliberate, not accidental. Establish lawful bases for processing and enforce data minimization and purpose limitation by design rather than by after-the-fact cleanups. The General Data Protection Regulation, GDPR, offers a common vocabulary for bases like consent, contract, legal obligation, and legitimate interests. Whichever basis you choose, tie it to records that show why it applies and where it ends. Data minimization means collecting only what is needed to achieve the stated purpose. Purpose limitation means not repurposing data without a new basis or notice. Build these checks into intake forms, event collectors, and analytics pipelines so that defaults favor less data, shorter retention, and fewer copies. Architecture that prevents overcollection beats audits that scold it later. Records of processing are the connective tissue that make reviews fast and defensible. Build records of processing activities, ROPA, that name the owner, the purpose, the data categories, the data subjects, the systems involved, and the recipients, internal and external. Link entries to data flow diagrams so a reviewer can click from a purpose to the actual pathways the data takes, including batch jobs, third-party APIs, and export routines. Add jurisdictions and cross-border notes so location-specific duties are immediately visible. Treat ROPA like a product backlog with owners and freshness dates, not a spreadsheet graveyard. When audit time comes, you will answer, "Where is this data and why do you have it?" with a single source of truth, not a scavenger hunt. Data subject rights are about speed and completeness, not heroics. Script handling for access, correction, deletion, and portability with deadlines, evidence, and fallback rules when data must be retained. A Data Subject Request (DSR) playbook should route tickets to accountable teams, enumerate systems to query, and define response closures with attachments that prove fulfillment, exports, redactions, and approvals. Deletion must include derived stores, caches, and backups with realistic methods for deferred purge, where immediate deletion is impossible, paired with documented controls that prevent restoration. Portability needs machine-readable formats that reflect real schemas, not bespoke dumps that take weeks to recreate. When the playbook is tested quarterly with time-boxed drills, responses become routine rather than adrenaline events. Cross-border transfers require deliberate mechanisms and tidy paperwork. Choose transfer instruments appropriate to each route and partner. Then document the standard contractual clauses, SCCs, adequacy findings, or intragroup agreements that apply. Annotate your data flow maps with transfer paths so reviewers can see which streams rely on which safeguards and where supplementary measures, encryption, access limits, local processing, shore up gaps. Keep vendor due diligence files aligned with these mechanisms so contractual promises map to actual controls and monitoring. When a jurisdiction's rules change, you will know exactly which flows to review and which contracts to refresh because the links already exist on paper. Breach notification is a race against the clock and confusion. Set thresholds, timelines, and roles for regulators, customers, and partners so the escalations are mechanical rather than improvised. Define what constitutes a notifiable incident under relevant laws, what evidence establishes that threshold, and how the investigation timeline intersects with notification windows. Clarify who drafts notices, who approves them, who sends them, and which artifacts, tickets, logs, containment steps accompany the message. Include partners and processors in the plan because their delays become your delays. Build contract language that compels timely sharing of facts. When the worst day comes, pre-written templates and decision trees will trade panic for execution. Retention is where legal, risk, and operations must sing in the same key. Align retention schedules to legal and business requirements, then automate deletion workflows safely across production systems, analytics stores, and backups. The schedule should specify durations for each data category, the rationale behind them, and hold conditions that suspend deletion for litigation or investigation. Automation should use reversible steps where feasible, tombstoning before purge, and generate evidence logs that show which records were removed and when. Safety valves are essential. Batch sizes, approvals for high-risk deletions, and post-run checks that confirm integrity. Retention that runs on rails cuts storage costs, reduces breach blast radius, and proves discipline to regulators. Privacy by design must be part of how software changes move, not a separate ritual. Embed privacy reviews in the software development lifecycle, SDLC, with data protection impact assessments, DPIAs, triggered by specific conditions. New personal data, new profiling, new sharing, or new high-risk processing. Provide risk review checklists that convert principles into answerable questions and attach decisions to issue trackers so context travels with the code. Default to privacy-friendly settings in features that expose personal data, opt-ins rather than opt-outs, coarse retention values rather than forever, lower granularity by default. When privacy lives in tickets, code reviews, and configuration baselines, it scales with development instead of trying to chase it. Vendors extend your footprint, so contracts must carry your duties forward in detail. Lock down data processing agreements, DPAs, security clauses, and audit rights that specify controls, breach notice windows, and subprocessor transparency. Require flow-down obligations to any subcontractors so responsibilities do not evaporate one hop away. Tie contract terms to practical verification, pen tests, reports, certifications, and uptime metrics, and set correction windows with remedies that bite. Maintain a living vendor inventory with risk tiers, data categories handled, jurisdictions touched, and the dates of last review. If a provider cannot meet the bar, the risk decision must be explicit and time-boxed, not silently absorbed. Evidence is your shield. Collect artifacts, policies, training rosters, records of processing, DPI files, DSR tickets, approvals, retention logs, and breach communication templates in a structure that mirrors regulations and your own policy framework. Index them by system and by requirement so both audits and investigations can navigate from rule to proof in minutes. Refresh cadence matters. Training completion every cycle, policy reviews annually, DPI rechecks when features change, DSR drill results quarterly, vendor attestations on contract anniversaries. When evidence accrues as part of normal work rather than during audit sprints, you gain credibility and save energy. The operational close is a register that makes all of this visible and actionable. A compliance register should list obligations, the systems and vendors in scope, the owners, the current status, the next verification event, and the evidence location.
Link it to your risk register, so privacy and legal exposures live in the same planning language as other risks, with treatment plans and residual statements. Use the register to drive meetings. What is due this month? Which items slipped? Which incidents triggered re-reviews? And where thresholds were crossed? When the register becomes the meeting agenda, compliance becomes a management practice rather than a periodic audit performance.
In conclusion, treat compliance as the no surprises guardrail system that enables speed by removing uncertainty. Identify the rule sets that actually apply. Define and locate personal and sensitive data. And build lawful bases, minimization, and purpose limitation into design. Keep records of processing current. Script and test data subject rights. Choose and document cross-border mechanisms, and prepare breach notifications with clocks and roles. Align retention and deletion to what the law and the business require. Embed privacy in the SDLC with DPIA triggers. Harden vendor contracts with clear flowdowns and audit rights, and balance monitoring with consent and necessity. As a concrete next step, create a compliance register that links obligations to systems and owners, and kick off one high-risk DPIA this week so the program demonstrates motion, not promises. Thanks for listening. For more audio courses, daily newsletters, and more, please visit DailyCyber.News.